So the first section that we're going to look at is the different management structures, and there's actually quite a helpful leaflet that Chris has put on your chair, which I won't be sticking to, but it's useful for you to take away with you, because that's been prepared by Premier and has quite a lot of information about different types of management structures that can be put in place for your block. And what I'd like to say right at the beginning is most developers who are doing a conversion of a building into a block of flats or building a block from the ground up do not start off by thinking, what would be the best way for the residents for me to set up the structure of the block? That is not in their thinking. Their thinking is, do I want to have a good exit strategy to take the maximum profit from my development? And therefore, you will often find that the structures that are put in place are perhaps not the ones that you would have liked to see as the resident in the block. And I'm not saying that they set out to create problems for you, but they are not really thinking about that. That's not what they're thinking about. So when we look at these structures, and you sometimes think, well, why didn't they do whatever would be best for us? The reason is that they weren't thinking about you, the ultimate occupiers. They're only thinking about people buying their flats and then paying off the debt that's been incurred in building the development. So on the first slide, there are two main and common types of structure. The first one on the left is where you have a landlord who grants leases of the individual flats. The landlord has retained responsibility for providing all the services and the management of the building and the structure, and he will enter into a contract with a managing agent who will deliver those services. The managing agent is not a party to the lease, and the managing agent, in those cases, the landlord appoints the managing agent, and the tenant has very little control over who the managing agent is. On the right, we've got the slightly different option where you have the landlord and you have a management company who are covenanting, who are giving the obligation to maintain the building, and they are a party to the lease. And then the occupational tenants are the ones obviously paying the service charge. In that scenario, the management company would usually then appoint a managing agent to actually carry out the function. It would be quite unusual to have a management company that carry out that function, although there are companies that do. I don't think they apply particularly in the city centre, but certainly some developers have a pet company who are a party to the lease. They're not specific to that development. They have a management function and they deliver the services direct. In some circumstances, the management company is actually controlled and owned by the occupational tenants. So when you get your lease, you also get a share or membership of the management company. And obviously, if that happens, you then have rights under the company's constitution as far as appointment of agents, control of what's done in management and so on is concerned. And indeed, in some developments, the developer will set it up so that ultimately the freehold interest in the building may get transferred to the management company. And in that scenario, obviously, you, the occupational tenants, end up with effective control. But that often isn't the way that the developer wants to do it, because it doesn't maximise their profit out of the development. So you can have another scenario where the freeholder grants a lease of the whole building to the management company, and then the management company grant leases to an occupational tenant. Now, why might they do that? Well, one of the reasons for doing that is that the freeholder may want to be free to get rid of their interest in the building to a third party. So the value in the building for them once the development is completed is their right to receive the rent, the ground rent. If they put this structure in place, then they're pretty free to dispose of their freehold interest without reference to the occupational tenants. Now, we're not going to go into a lot of detail today, and it's not on as a topic about enfranchisement and rights that tenants have if the freeholder wants to sell his interest. But this structure actually gets around that right because the freeholder's immediate tenant is the management company, not the occupational tenants. So the other options here are you have a landlord freeholder who has a management company or is a party to a lease. They grant rights and covenants to manage the property, and they grant the individual leases. And then the landlord freeholder may also grant a common parts lease to the management company so that they actually have rights or interests in the structure of the building, and then they would contract with the managing agent. So you can already see there's loads of different options, and there are as many different scenarios as there are buildings. The most complicated one that I'm aware of in the city is Albert Dock. Not only do they have numerous layers of leases through the different buildings, but they have numerous different companies and obligations and different bits of service charge involved, and it's extremely difficult to work your way through all the layers of the leases to work out exactly what's going on. So, from the point of view of the management structure, what we need to look at is who is responsible under the lease, who controls the management company, does the landlord have control of the company, and with whom is the managing agent's contract. So taking those very quickly, the first point, and I'm sure Jerry would emphasise this as well, is what does your lease say? What does your lease say? How is the lease structured? Does the lease say that the landlord maintains the property or that the management company maintains the property? Is the management company controlled by the landlord or is it controlled by the tenants? Now, the other issue on the control of the management company is that you can, and we'll look at this a little bit later on, is you can have different types of shares in the management company. So the management company may have been set up so that the residents get a share, but that the landlord retains a controlling share, a voting share that means that they always have the controlling interest in the company. And obviously that means that you think that you've got control. You think, I'm a member of the management company, I'll be able to go to the meeting, we, the residents, will be able to sway everything. Look at the constitution of the company and find that there's a preference share held by the landlord, which means that they would always have a controlling vote in the company. So does the landlord have the control of the company? And in some cases they do. The other thing that I think we sometimes find in practice is that everything's been set up so that the intention would be that the rights would all pass to the management company when the development's finished, but that the landlord hasn't given the control of the company to the residents until the last flat is sold. That never used to be particularly a practical problem. Now we are dealing with developments that were built in 2006, 2007. Not all of the flats were sold. They're still not sold. And so 7 or 8 years on, although the original intention was that the management company would become controlled by the residents, that those rights have never passed because the landlord hasn't finished selling his development, and that's caused quite a problem. Is the managing agent's contract with the landlord or is it with the management company, and do you have control? And then very quickly here, there's two types of management company basically. companies limited by shares and companies limited by guarantee. We would always recommend that a management company is a company limited by guarantee. The reason for that is entirely practical. If you have a company limited by shares and somebody's lost their share certificate, it's quite a performance to get the company to issue a new share certificate to the new owner. If it's a company limited by guarantee, you are a member, and all that happens is you write to the management company and you say, X has sold their flat to me, they have ceased to be a member and I'm a new member, and they just make a record of it in the company books. There's no need for anybody to find a share certificate. So it's really a practical variation that we particularly think is better. So just very quickly to emphasise, a company has a separate legal identity from its shareholders. It is a separate legal person. So if a company enters into a contract, it's the company entering into the contract as distinct from the shareholders. The liability of the company is limited to the assets of the company, not limited by the assets of the shareholders. There are formalities for the company to function. They have to file returns at Companies House. They have flexibility about setting what their tax year is. There are reduced formalities for small companies, so they're not, if you're a small management company managing a block with 6 flats in it, you don't have the same filing requirements as ICI. But you do still have to be recording your records publicly, and you have to be, something that we'll talk about later on, transparent, and you do have to set up meetings and have a proper structure which is governed by the company memorandum and articles. So the shareholders own the company, the directors manage the company, the directors are appointed by the shareholders. The shareholders have ultimate control, so they can get rid of the directors and change them. But the directors have the daily control through board meetings. And the same would apply in a management company, just as in any other corporate structure. If you don't comply with the legal formalities of running the company may be struck off the register. This has been an enormous problem with various blocks over many, many years. People have had a company that controls the management of the property. They failed to make their annual returns. The company gets struck off the register. You then have a situation where the person who has the legal responsibility for carrying out the management function has ceased to exist. The managing agent hasn't got anybody that they're contracted with. There's nobody potentially who has the legal right to recover the service charge. So if people stop paying, you have nobody who can recover the money. So there are problems, and most managing agents will run a company secretarial service for you. I don't know if you do. Yes. Yeah. Most good managing agents would offer the residents a company secretarial service. It's unless you have a resident in your block who is experienced in doing that, it is money well spent, because they will make sure that your annual returns go in on time. Any changes in the directors, any changes in the registered office of the company are all recorded. They will make sure you do not slip up on what is just a technical aspect of running your company. Solicitors can do that for you as well. Sorry, I'm not trying to do myself out of a job. But obviously, if your managing agent is the person you have day-to-day or month-to-month contact with, then they're the people to do that for you. Right. So, do you want to take questions now on this section? Right.
That's a lot of information.
Sorry, a lot of...
That's really, my head feels a bit mad with all those options and diagrams. Basically, we're just looking at this stage at the whole array of what the options and possibilities are. I don't know whether anybody wants to come in with a question or a clarification at this point. We're going to develop in detail issues around mixed use. They're slightly different, where you've got commercial and residential together. And we're going to look in detail at right to manage and resident management companies as well, looking at how those happen. And so those questions around those issues are going to come later. But if there's anything on the first section, Ryan.
In terms of being set up as a company under guarantee, what's the method for getting funds and cash into that company? So if the residents aren't purchasing shares for capital in the company, where's the funds coming from?
For a company limited by guarantee, the most companies limited by guarantee would have very little actual capital in the company. But then that would be true of a company limited by shares. You'd probably have a £1 share, and if you've got a block with 20 flats in, the original capital of the company would still only be £20.
So there wouldn't be any admin expenses put through that actual management company?
The day-to-day management would be the monies collected and expended. So it would be, you wouldn't be using a management company limited by guarantee for generating money other than money that was being spent on the building. So if the residents need to do if there needs to be structural repairs, you would collect money in by service charge and expend that money in the normal way. It wouldn't then be held by the company. The company would really just be effectively like a shell. It wouldn't have particular assets of its own.
I think either way, whether a company is limited by guarantee or by shares, that company exists purely to form a party to the lease when service charges are involved. So actually, the recovery of funds and the spending of funds is dealt with by the service charge. The company is there because more than one person needs to be that body that spends the money and collects the money. And therefore, one solution, so way to do that is to have a company with, let's say, 10 members for 10 flats, and then everyone is involved in that management.
Wouldn't be trading with the public. So
No.
No,
but
income stream basically is just managing the funds the money from its own shareholders. So there's no trading taking place.
First thing in terms of the company secretarial services and that just happened.
Oh well, you'd have to all of that in a well-drawn lease. You would include the costs of having the company administered as part of one of the heads of service charge. So the expenses of running the company would also be collected from the residents as part of the service charge, so the company secretary services. But
that'd be kept separate.
Yeah, they would. Yes, everything. There would be a capital account in the management company's books. That capital account would show a tiny. It'll be whatever the set-up seed was. All of it will be to do with the income and outgoings of the books. The other thing is, of course, they do have to contract, and that's the protection effectively for the residents. If you had to if you just had a group of residents who managed the property, I can't quite see how you would set that up legally, but let us say that happened, and it potentially can happen with very small blocks. I have come across it more in London than anywhere else, where you get a house that's 2 flats or 3 flats, and the structure is that the 2 flat owners or the 3 flat owners jointly own the freehold, and because it's such a small development, they do it together, and they hold effectively on trust. The 3 flat owners hold the freehold on trust for the others, and they haven't bothered to set up a company to do it. And in that situation, the 3 trustees effectively would be contracting with anybody providing services, but it's much easier for the company to be the name on the contract. So, if you've got common parts with an electric supply, the contract needs to be with the company.
In the UK, probably in England and Wales, more than the UK, we're pretty much the only place in the world that has leasehold. Everywhere else tends to call them condominiums, or we have an equivalent of it called common hold, but it's hardly ever used, where exactly that setup that Jane explained exists, where you jointly own the freehold and you're jointly responsible for management, rather than there being leases granted and different people owning different parts, in effect, or letting different parts.
In fact, in Scotland it's different. You have freehold flats in Scotland, which I find incredibly hard to get my head round. You know, so we are quite, it is quite an unusual legal structure. But obviously we like it so much that when they came up with something else, common hold, how many are there? 3 common hold associations registered in the country. 19 now, there you go.
Okay, a quick last one because we need to move on.
You just said that you like it so much, the leasehold sort of system in this country. From my own experiences, and then from seeing the complexity of all the different setups there, I don't like it very much, because I think none of it is in the interest of the actual leaseholder that lives there.
Well, I'll let Chris answer. There's one very important legal reason why you have leases, which is for your benefit. In England and Wales property law, there are what are called restrictive obligations which attach to the land, and they go on running. However, the positive obligations are regarded as purely contractual and only bind the original parties. So if you and I have an agreement that says you will do something, not that you will not do something, that's binding between us. If you then dispose of your interest to the person sitting next to you, that obligation was only personal to us. So we can't enforce that positive obligation. Under a lease, this is all sort of the legal framework of it, under a lease, that positive obligation goes on because of the obligation to pay rent, even if the rent is a peppercorn. So even if it's technically nothing, the positive obligation is binding between us. That's why the idea of leases has grown up. So